My clients often ask me, do I need a will? Well, I often tell them, yes, it's very important to have a will. If you don't have a will, the statutes of the state of Illinois will dictate how your property is to be divided upon your death. And that's based on who your nearest relative is that's living. However, if you have a spouse and children and you don't have a will, the Illinois statutes dictate that half of your property goes to your spouse and the other half goes to your children. Oftentimes, this is not what people's intent or wishes are. They would rather have everything go to their spouse, and then if they are the second spouse to pass away, then to their children. So in a situation like that, again, I strongly recommend that you have a will drawn up. Now, the other instance where a will is very important is if you have minor children. In a will, you can dictate who takes physical custody of your minor children if both parents were to pass away. You also get to name a guardian of the children's estate, which would be a person that manages money for the children if they're minors and both you and the children's mother or father pass away. Please understand that wills only deal with property in your estate. You might hold property in another form of ownership, such as joint tenancy. In that particular situation, the property would not pass by way of your estate in accordance with the will, but rather would go to the surviving joint tenant. The other way property can be held would be tenancy in common. In that situation, property would be considered part of your estate and would be governed by a will. Now, in certain situations, such as life insurance policies, retirement accounts, there will be a named beneficiary. In that situation, property is not going to be governed by your will, but rather will go directly to the beneficiary independent of your estate. So, considering all circumstances surrounding who your relatives are, how your assets are held, will dictate whether you need a will or not. However, I can tell you chances are what the statutes provide are not going to specifically encompass what your intent is. And in that case, I strongly suggest you sit down with an attorney and decide if it's in your best interest that you have a will drawn up.